This is a live update. A shocking development just unfolded moments ago, and what it reveals changes everything about a case that many assumed was already settled. According to official records released this morning, the nation's highest judicial body issued a final order that decisively shut down the last remaining legal escape route. Sealed filings, sworn statements, internal correspondence. Until now, these documents had never seen the light of day. And at the center of it all is an unexpected move by Ilara Vaughn, the former spouse of ex-Executive Council Chair Adrian Vaughn, that has sent tremors through every corner of the legal system. Before we go further, subscribe right now, because what you're about to hear is not being explained clearly anywhere else. Every detail matters, every timestamp matters, and the stakes could not be higher. This morning, precisely at 10:03 a.m. Eastern, the High Federal Tribunal issued a one-sentence order. No oral argument, no detailed opinion, just two words: application denied. 9 magistrates reviewed the filing. Not one dissent, not one concurrence, no explanation offered, because under their own rules, none was required. That order became effective immediately. With it, months of procedural maneuvering vanished overnight. What makes this extraordinary is the timing. Exactly 72 hours earlier, attorneys for Ilara Vaughn submitted a proffer agreement to federal prosecutors. That agreement, now part of the official docket, outlines the evidence she is prepared to provide in exchange for immunity consideration. 2 seismic legal events, separated by just 3 days. Think about that timing. That is not coincidence. That is coordination. Now, before anyone dismisses this as political theater or tabloid drama, let me be clear. I'm not making accusations. I am reading what's in the file. These are court filings. These are sworn affidavits. These are contemporaneous notes released as evidence. They exist. They are logged. They are legally operative. Here's what has just become binding law. Ilara Vaughn has voluntarily waived spousal privilege. That protection, which normally prevents prosecutors from compelling testimony between spouses, has been set aside by her own hand. And the materials she is offering fall into 3 distinct categories, each more consequential than the last. The first category is financial documentation. According to the proffer, she is providing 6 years of jointly signed tax returns covering fiscal years 2014 through 2019. Each return bears her signature beneath a declaration stating the information is true and accurate under penalty of perjury. These returns rely heavily on asset valuations, commercial properties, licensing entities, foreign holdings. Internal valuation schedules attached to the returns differ sharply from those presented to lenders during the same periods. Read that again. The numbers don't just drift. They move in opposite directions depending on the audience. The proffer includes internal spreadsheets labeled reconciliation drafts, showing side-by-side comparisons of reported values. In the margins are handwritten notes, initialed EV, asking why one property is listed at $48 million in loan materials, but under $23 million in tax filings. That note is dated April 17, 2017. This is not recollection. This is a document, contemporaneous, precise, verifiable. The second category is communications. Tens of thousands of messages were produced, according to an inventory attached to the agreement. Text messages, emails, encrypted app transcripts. Many are mundane. Some are not. There are email chains between Ilara Vaughn and senior accounting staff referencing adjusted figures before meetings with lenders. There are text messages sent hours before bank calls reading, confirm North Harbor valuation version C. Version C, according to an internal index, reflects the highest appraisal number. And then there are the recordings. Let me be precise. The proffer references 4 audio files, each time-stamped and logged with metadata verified by forensic analysts. In one, dated March 12, 2020, you can hear a voice identified as Adrian Vaughn discussing projected revenue from a resort property. A second voice, identified in the transcript as EV, interjects to correct a figure upward, noting, "That's the number we used last time." Prosecutors describe this recording as material corroboration, not once, not twice, repeatedly. The third category is testimony, not opinion, not conjecture. Testimony under oath. Ilara Vaughn is prepared to testify that she was present during multiple meetings where discrepancies between bank submissions and tax filings were openly discussed. She will testify that she questioned those discrepancies, and she will testify that she was told repeatedly that the differences were strategic. Read that phrase again, strategic. That is not casual talk. That is intent. Now, here's the part no one expected. The proffer agreement includes a clause stating that privilege is waived for all matters described therein. Word for word, it reads, "The witness knowingly and voluntarily waives any marital or spousal privilege with respect to the subject matter of this proffer." That sentence alone detonated the emergency appeal filed less than 24 hours later. Defense attorneys for Adrienne Vaughn filed an emergency application with the High Federal Tribunal asking the court to block the testimony before it could reach the grand jury. They argued marital privacy protections, alleging coercion and undue influence. But the court did something telling. It docketed the appeal, but it did not issue a stay. That matters. When a high court believes an appeal has merit, it freezes the underlying action. Here, it didn't. Proceedings continued. Silence in this context spoke volumes. Yesterday morning, the appeal was distributed to all 9 magistrates. By tradition, any justice could have requested further briefing. None did. And this morning at 10:03 a.m., the application was denied. No dissents, no commentary. That level of unanimity is rare, especially in politically charged cases. It tells us something about the court's view of the underlying law. So why was the appeal rejected so cleanly? Because the law here is settled. Decades ago, the court ruled that spousal privilege belongs to the witness, not the defendant. If the witness chooses to testify, the defendant cannot stop it. That precedent has been reaffirmed repeatedly. The defense argument wasn't novel. It was recycled, and it failed. But it gets worse. Along with the proffer, Ilara Vaughn's attorney submitted a sworn affidavit stating she initiated contact with prosecutors. No subpoena, no threat, no leverage. Her counsel reached out first. That affidavit directly undercuts any claim of coercion. Federal courts look at voluntariness above all else, and this filing leaves little room for doubt. Let me walk you through the last 72 hours because the timeline tells its own story. Monday, 2 p.m. Eastern, the proffer agreement is submitted. Tuesday, just after noon, the emergency appeal is filed. That speed suggests preparation. They knew this was coming. Wednesday morning, the appeal is docketed without a stay. Thursday today, 10:03 a.m., it's over. Application denied, case closed, procedural escape routes evaporated. With the appeal denied, the path is clear. The grand jury can hear testimony immediately. According to scheduling orders already on file, that grand jury meets twice weekly. Prosecutors are ready, the witness is prepared, and there are no procedural barriers left. What happens next depends on what she says under oath. And according to the proffer, what she says aligns with what bankers, accountants, and appraisers have already testified to. Corroboration is the backbone of federal prosecutions. One witness raises questions. 3 witnesses establish patterns. Documents seal cases. Sit with that for a moment. This isn't about one filing or one order. It's about a chain of evidence built piece by piece, now reinforced by someone who was in the room when the decisions were made. This is rare. This is powerful. and it changes everything. The financial documents, communications, and recordings together form a pattern that is legally significant. Spouses rarely step forward voluntarily. When they do, it is usually under pressure or as part of plea agreements. Here, the initiative came from her. That is unprecedented at this level. Let's talk about strategy. With the testimony cleared, prosecutors face a decision that will define the next phase. They can proceed to trial on the existing charges armed with a stronger narrative, or they can seek a superseding indictment. That would allow them to add charges based on newly available evidence, conspiracy, wire fraud, false statements to financial institutions. Each carries its own exposure, and each widens the lens beyond bookkeeping errors into coordinated conduct. Timing is critical. The trial date is already set. Judges don't like delays, but they recognize when the evidentiary landscape changes. Cooperation from a central witness is one of the few reasons courts tolerate adjustments. Watch the docket closely. If you see new witness subpoenas issued within 2 weeks, that's a signal. If filings reference additional overt acts, that's another. Prosecutors telegraph moves in procedure long before they announce them publicly. Let's also consider the defense, because silence isn't strategy. They will respond. Expect a motion to exclude testimony. Expect attacks on credibility. Expect claims of bias and motive. That is standard. But here's what won't change. The documents don't lie. Numbers don't negotiate. And recordings don't forget. There's also a broader precedent at play. This isn't just about one individual. This sets a line around spousal cooperation in complex financial crimes. For decades, defense teams have relied on privilege as a shield, not always successfully, but often long enough to delay proceedings. That shield has just cracked, publicly, decisively, and the court didn't hedge. It didn't narrow. It didn't caution. It denied cleanly, unanimously. That sends a message down the judicial chain. Voluntary cooperation stands. Delay tactics fail. The law applies evenly. Now, consider the moral dimension. When financial systems are manipulated, the harm isn't abstract. Banks adjust risk models. Tax burdens shift. Trust erodes. These cases aren't victimless. Accountability isn't about punishment alone. It's about restoring confidence that rules mean something. Think about what this required. A former first spouse stepping forward, waiving protections most assume are untouchable, providing records implicating someone once at the center of power. That doesn't happen casually. It happens when the weight of evidence outweighs loyalty. Long-term implications are immense. Future investigations will cite this. Prosecutors will reference it. Defense attorneys will warn clients. The assumption that marriage insulates financial conduct has been weakened, perhaps permanently. So where does this leave us tonight? Here's what we know. The final appeal is over. The testimony will be heard, evidence is layered, corroborated, and partially tested. The timeline has accelerated. The stakes have risen. What we don't yet know is how far this will go. Will prosecutors stop at strengthening the current case or expand it? Will additional witnesses emerge? Will more documents surface? Answers will come quickly now. This is not spectacle. It is process. And today, the process moved forward. The law applied evenly. The court acted decisively. The system worked as intended. Thanks for watching. Subscribe, share this, and stay alert. Don't let anyone tell you this doesn't matter, because it does. Follow this case closely. The next 30 days will reveal the prosecution's strategy, the defense's response, and how this extraordinary cooperation will reshape accountability at the highest levels.